Hi everyone, it's Grant Abbott and welcome from Abbott-Family LightYear Dogs, and of course I love SMSF, which is sort of just in a holding pattern at the moment, although we have got a number of things planned for it. And this is a very auspicious day, and I've been promising it to you for a long time, that there would be changes to the 4-member rule, and I'm going to take you through that. It's pretty simple actually. But there's been a lot of brouhaha. It almost made it in prior to the last election, but unfortunately the bill that they tied it in with was a beer excise bill, which got through, but the 6-member fund didn't. So finally, this is really important from a political perspective, in that the reason they're doing the 6-member fund is to drag money from the industry funds, which have become all the more powerful. And particularly if you have a look at some of the large ones like Australian Super, Q Super, which is now, I forget who they're joining up with, but we're getting some big behemoths. I think apart from SMSFs, we're only going to end up with about 5 or 6 funds in the long run, which would be great. Retail, probably not to any great extent. You can see most of the banks are throwing their hands up around investments and investment strategies. AMP may still be there, or we don't even know if AMP is going to be there in a few years anyway. But certainly around our area, it's really important, and that increase of the number from 4 to 6 is going to have a really big impact. And I want to take you on a bit of a journey, and a bit of my journey anyway. Q Super plus Sun Super, thank you very much for that. So much appreciated. As I said, if you haven't booked in for the course, make sure you do. There's some great discounts. Honestly, this will probably be the cheapest course you've ever done. If you can't do it over that time, or you can just drop in and out, still just drop in and out, because you can always make up the other modules there. For those of you who are coming, we will be sitting an examination, which is a multi-choice examination, on the final day, but don't worry, I'll give you plenty of warning on the sort of questions that we've got, which is exactly what my law professors used to do. They'd say, well, please take note of this, because you never know when it might be in an examination. So we're going to have a look at this. So family super funds are the next step on for SAPEPAA and SMSF advisors. I remember starting to use that term way back in 1998, actually. Just after that little breach in May 1998, they changed the laws and moved the regulator over to the tax office, and changed the definition of self-managed, primarily 4 members, but prior to that date, not all members needed to be directors, nor did they need to be trustees. And likewise, for those of you who've been following me, you still don't need to have that case either. So we're going to have a look at a lot of those sort of strategies, some ideas. Now, this is fresh off the boat, as they say. It's gone through the House of Reps, gone through the Senate, so just awaiting royal assent. So it's supposed to apply the first quarter after royal assent. So it's either going to be the July quarter, or alternatively the September quarter. September, I think, is not a bad idea, because we're going to need to marshal our ideas. We need to get our clients focused, particularly for those of you down that SAPEPAA track. We need to get them focused that this is one of the core planks, or one of the core big turrets of the castle that we need to build out. Look, I've seen, and look, you know, I saw recently a client with a substantial amount of wealth and only $250,000 in their super, and effectively they were over age 60, so they got full access to their monies. And then, you know, playing around with Div 7A, playing around with a lot of stuff. So I'm going to go in and restructure them and make a huge difference over time. Can't do a huge amount right at this present point in time, 30 June, but we will be able to have a lot of fun there. So SMSFs are really opened up, and you're going to see why as well. You know, ask questions along the way, but again, we're going to be going through a lot. Here's the big draw card for us, and this is why you can see the federal government, the Liberal coalition, have basically gone that. Did you know that there's over $1.3 trillion sitting in accumulation accounts of under 50s? And sorry, I should say that is, in fact, I'm going to change the slide there. It's actually the, let me just bounce out of here, because I think that that's a bit of over 1.3 sitting in accumulation accounts of APRA super funds for under 50s. So, because I want to give you these slides afterwards as well, and I'm going to give you a few juicy things for this anyway. So I think that in itself really talks about where we're going. For those of you who are financial planners in the audience at the moment, this is probably the biggest area. I mean, it's bloody hard to deal with retail super, etc. But setting up self-managed super funds, doing the investments, potentially we're going to go down and look at what you should be doing. There's a really huge opportunity there for SMSF investment strategists, obviously with a financial planning license. And we'll start to work into that a little bit later on, and I'll talk about that. But that 1.3 trillion, you can see the government really wants this sort of money to flow into self-managed super funds to dilute the impact of industry funds. And with increases SGC over time, it's going to be, look, I think it's a huge, it is a huge opportunity. I think you guys know anyway. I picked this up from the ATO stats. So this is at 30 June. There's 593,000 SMSFs. So that's actually gone down, which is, I think, is important. And this was taken at 30 June 2020. So you can imagine there was quite a few wind-ups from self-managed super funds, particularly the older brigade after COVID. Look, at some point in time, there's going to be another big correction. So let's hope the industry funds aren't running at such short cash at the moment. But there's $733 billion in total assets, which is fantastic. It's still around about 30% of all superannuation and more than 1.1 million SMSF members. Now, if I take you back to this one, which is quite interesting, if you have a look there, that $1.3 trillion, that's sitting in the accounts of around about 21 million Australians. So there's 21 million superannuation accounts. So there's huge chalk and cheese between the two. Assets of over 1.3 million each on average. So it shows you it's really that high net worth. And of course, the more members that we have in, the bigger these are going to grow. And I think that's the crucial amount. Because typically, if you had a look at a 30 or a 35-year-old or a 40-year-old, they may not have the requisite amount to, set up one of these funds. But essentially what we can have is, for that perspective, is that they join with their mum and dad's funds. Then you'll be in the right position. Here's one of my bit of go-tos, or one of the strategies I think will be populated down the track. I think we're going to find that much the same as we might have a number of individuals going into, say, syndicated unit trusts, and that was 20 or 30 years ago. I see there's an opportunity there for SMSFs to become like mates SMSFs, so that provided you've got good structure control, agreements as well, which are embedded into the deed, that in essence that we can have 4 or 5 mates who are in there investing like their superannuation investing club. Again, we've just got to be extremely careful about the ins and outs, the exit strategies, because again, it's just the same as a divorce. It's probably more chance of a divorce, but if someone wants to leave and set up their own family super fund, how are you going to do that? But I do see that's the case, and I've already seen that happen on a number of occasions, but unfortunately, it's usually the setup is very poor. But that'll be good. 55% of SMSFs have existed for more than 10 years. The rule against perpetuity doesn't apply. I'd like to see this in 50 years' time, that we've got, 70% of SMSFs have existed for more than, 50 years, because they're not going away. So they're going to be there. They are clamping down on it a lot. It's not, for me, it's not the greatest, it's not the huge tax tool it once was, but it's still an absolutely brilliant tool down the track. And importantly, from that perspective, if we have a look at that, we've got Mr. Michael Jeffriess there, who's on the line. But as we look down the track, we're going to start to see these getting bigger and bigger. And I think that, full credit to the Liberal Party. Obviously, if Labor get in, and I would expect, as I've said before, I think we're going to go to an election in October or November this year, possibly just after the Melbourne Cup or in between the footy finals and also the Melbourne Cup. But, this time is right. I believe, we come out of COVID, everyone's positive. the government's, stuffed up a few things, but there's no way in the world like this that they're going to go and effectively put Labor in. So that means we've got another 3 years, which I think of the coalition, which means that SMSFs are safe and also really LRBAs are safe. And I think that that's really crucial.
They might even go...
median age of SMSF newly established members was 46. So it shows you again, because of the skew, there's really not that many people set up in SMSFs once they're over 60. So it really shows you if that's the median, there's probably not that many that under 40 are really sitting in there as well. But look, it's 61 for all members, which is important. So it's a really old cohort that we're looking at. So we want to bring in that fresh blood, and I can see it already. As I said, there's over 600,000 SMSFs going back 18 months ago, and they've dropped down quite considerably. So we're not getting that growth in those new funds that we once had. And of course, probably the last year, everyone's been so worried about the COVID, they've taken their money out. All those younger balances have actually gone and dissipated with that 20,000 drawdown, which is not a bad thing, I think, personally. It was the best thing that got us through there, and hats off and kudos to the government. Of course, there was big scare campaigns from the industry funds, but they'll do scare campaigns on anything anyway. Average member balances, we don't have to worry about that. I think they've both increased. It's interesting, estimated return of assets to 2018, 2019 was 6.8%. So I just wanted to go through a timeline. So before 1994, we had the Occupational Superannuation Standards Act, which, believe it or not, was very close to the High Court judging it as being unconstitutional, because essentially when we have a look at that, thank you very much, Chris, well done. Anyone, if you ever need to make an appointment with me, technical, I'm not doing so many emails anymore. I'm preferring to get on the phone and sorting your questions out. If you're a strategist member, make sure you contact Chris. Chris, do you want to put up your email address so that people can email you if they want to make an appointment with me? Anyway, getting back to the Occupational Superannuation Standards Act, the government made a whole lot of rules previously, prior to 1987. All the rules around sole purpose test, RBLs and all that was sitting in the Income Tax Assessment Act in 23F and 23G, 121 DBA or DBA, good on you, Dan, DB funds, as many of you, some of the old crew like John Gowing, all that probably remember. Then we switched over to the Occupational Superannuation Standards Act, and that was under the Keating and the Hawke government. They wanted to put a bit more flesh around it. The only problem about that is they set up obviously a Superannuation Act, but inside the Constitution, when it was written in 1900, there was no rules around superannuation, wasn't even a word back then. So they had to madly scramble around, and they introduced the Superannuation Industry Supervision Act. In fact, I had a hand in making submissions on that for when I was at KPMG. I was involved in a number of the initial meetings around that, and looking at the whole concept of pensions, etc. So it was very, very exciting times in those days. Look, in those days, I was working at Rothschild and made some submissions. KPMG was actually the business taxes. So I made some submissions, was there, and then in 1994 I moved over to Rothschild and started talking about some of you just on the chat line. If you remember me back from there, I know Manish was. We went, that was my first days with account and all that, going out and working strategies through super, which I was very excited, because the way I saw self-managed super funds in those days was the pension and the tax. And I'd come from the tax side of KPMG, dealing with funds management and particularly life insurance companies, where you had a 0%, 0% being for annuity business, 15% for being super business, and then their traditional business, which was 45%, I think, at that stage. And that was, for example, with typical savings policies there. So you can see where I got this idea of having different fields inside that. So Rothschild allowed me, I think I did the first ever video on self-managed super funds in 1995. and then ended up starting up my own business, Grant Abbott Consultants, in 1996. And I did a lot of remuneration packaging, a lot of tax work, a lot of strategy work, a lot of super work, and then just ploughed into self-managed super funds from 1998. And that was quite exciting. So, I've spent so many years pushing this industry and still, have huge belief in it. But to be honest, my passion isn't sorry. I love SMSFs to death. I've got the t-shirt or the shirt to prove it. But I'm absolutely passionate about this SAPEPAA space because, SMSFs aren't for everyone. We want to get them in there, but we want to get them in there not for the investment side of things. We want to get them in there for the family wealth creation and wealth protection side of things. So just part of that whole SAPEPAA thing. So that's where I'm really passionate about them. So we had this concept called excluded funds. Prior to that date, you needed to virtually have a prospectus if you were a retail superannuation fund. There are a number of small superannuation funds. I know a good mate of mine, Kerry Bizon. I'm not sure if you're listening, Kerry, but you were in there right from the day. I think you've been telling me some of the old super funds that you set up, which was fantastic. And she's been there right from the start. She's even going to be telling me a lot about a lot of super strategies as well, and it should be good. Someone asked what happened to the SMSF political party. Look, so I had a choice there with a political party, and I think over the last 2 or 3 years, I've become very disillusioned in relation to politicians and politics in perspective. And so I had a choice, either do that or go down the SAPEPAA route. So I chose the SAPEPAA route. So I think we're all going to benefit more out of that than the SMSF political party. As I said, you're going to see the Liberal government, I think, in for at least another 6 to 10 years. So we'll have to wait and see on that one. Maybe, who knows. So excluded super funds, 4-member funds you're allowed there. So they're excluded from having to do prospectus. Brought them in on the day. They had to be regulated under Section 19, which meant all their deeds need to be changed because to make it constitutional, you either had to be a company or offering old age pensions, which is one of the reasons that you should never have a super fund with individual trustees, because effectively you can't take a lump sum out of it. You have to take an account-based pension and then commute. So essentially you don't want to be involved in that one, but it gave the government something to hang in their hat on, being the corporation's power and also the old age pensions power within Section 51 of the Australian Constitution. In the early days, there was no need for all members to be directors of corporate trustee or trustees. So it sort of went down the track in those early days. They were mainly business partner funds, actually, from the ones I've seen. In 1999, self-managed super fund definition came into being, and essentially that made all members trustees and all trustees members, but there were always exceptions to the rules, so that if one of the other members holds your enduring power of attorney, then they can act as director on your behalf. So, for example, for my children, they can be in my fund. I can be the leading member. I've got their EPOA. They can put their money in from their various superannuation funds. And I can do, in fact, there was a case last year, G versus G, where we can make EPOAs quite specific. So you can have just a superannuation EPOA. So you just jump onto our system, don't tick all the other stuff like financial and health. And you've seen me use that before. Just do superannuation, and that essentially does it for you. So that leading member can basically go in and run the whole show, which also makes it a lot easier, believe it or not, for administration, because you're only dealing with one person. Although in the new self-managed super fund rules, we'll have a look. I believe you need to have at least half the members sign off the tax accounts. So we'll have a look at that a little bit later on if I get the time. 2007, we saw Simpler Super tax-free post-age 60. That really took it up in that 1 year. Remember the transitional, there was obviously caps coming in after that. The government then said, well, you can have $1 million non-concessional, or in those days we call them undeducted, but they're now non-concessional contributions. And it was funny, in that 1 year, leading up to 2007, I think it was from 2006, the budget, to 2007, more than $50 billion was put into self-managed, which then saw self-managed come from behind. So it was in front of industry, behind retail, but actually overtook retail straight away, and then bang, took off from there. And we're still in a pretty good position, although really industry funds are getting very close to self-managed now because retail's lost its desire, I suppose. 2017 transfer balance caps, that's limiting the total capital, but we'll have a look at those. 2021, now we've got 6-member funds, so that's fantastic. So we can now bring in that younger brigade, which is all important. So again, just from that perspective, I would expect most of you on here are going to be in that visionary of the early adopters. So you're going to see what we've had to see. And look, I'd like to say that it was, this is a modern theory, but, I did the Family SMSF way back in 1998. In fact, I was a member of Mum and Dad's superannuation fund since 1994. So I've never known not to be in a Family SMSF. So it's really important. So we've got our early adopters there. You guys are going to be there as well. A lot of you are already in that SAPEPAA space. So when you deal with that, because everyone else, and it's going to be too hard for a lot of people. And so the laggards and the skeptics are going to say, well, you should only have a, mum and dad fund, which doesn't make sense. I mean, you have a look, if you've got a mum and dad fund, dad dies and mum's mentally incapacitated, which I've seen what happens to that. It's absolute disaster. It's a good question. I used to love the 1990s with Count Financial Investments, super insurance, finance broking, and happy clients. Now all the silos, unhappy clients. Yeah, I know. Look, I agree. But that can I just say something from the heart? I love the financial planning industry. I'm not again, as I think best interest duty, the fact that you're not paying commission, I think commission is really important in the long run. Otherwise, people don't get the services. It's been over-regulated with red tape, which is now why I'm seeing a number of financial planners moving away from that industry. I've seen licensed accountants have a look at that asset guideline. I've shown you about the exemptions for tax agents and accountants. A number of people who are in either camp now starting to move over into that SAPEPAA space, which I think is fantastic because it's more of an ephemeral, emotional space. And you're going to see that on that 3 days. We're going to be doing case study after case study after case study. We're going to be looking at some things, and I'm going to show you something a little bit later on, which I think is just going to blow you away. It's so exciting. So many of you are sitting down there in that space. I don't know what's happened. Here we go. If we go down, sorry. So the benefits. So SMSFs are not impacted by the rule against perpetuity, so they last forever. So obviously that's why we also want our trustees, our corporate trustee, to be forever. We want to make that a special purpose SMSF corporate trustee. You don't want shares, so you'll see when you go through and you build it on our site, it comes up ordinary shares, but you'll see it says non, and non just simply means non-dividend paying. And as a consequence of that, you can, and here's an important one, you can still act as a corporate agent, but get your client this year to pay 10 years ASIC fees in front, so you're never going to have late payment problems again, which has always beleaguered many of your clients and probably me as well. So that makes them ideal long-term family wealth creators, and as I've said, protectors. It fits really well within that SAPEPAA section. If we have a look at the $1.6 million, which is our general superannuation balance, the amount we can put in before we're clocked off in terms of non-concessional, 6 members in there, that's a $9.6 million fund. And that's just money we're putting in or assets we're putting in there, as opposed to actually the growth on those assets. So these funds can make a huge difference for them. Provides ultimate asset protection, which I'll show you a little bit later on. I'm a great believer that bringing in the younger families and then the super fund, much the same as you have group insurance with industry funds, that we'd also have that for SMSF. So sickness, TPD and life. And I do know a couple of friends of mine who are actually building life policies, group life policies for SMSFs. So I'm hoping that will be out very shortly, which will be fantastic. And I think that's just another added fillip for our industry. If you need to know more about that, just send Chris an email, and what I'll do is I'll put you on to the relevant person who is looking after, which is George Haramis down in Melbourne, who used to be the ex-CEO of Retire Invest. Many of you are probably aware of him, but they're coming up with a great SMSF group life policy. And I said, as soon as this comes in, it's really going to take off. Costs are more, you're going to charge more, but they're spread over more members. So again, why would you be paying any fees inside retail industry? The retail industry funds, they might only have smaller fees. I do notice they've all upped them from the 1st of July, but it's the underlying, the hidden costs within their investments, because they don't go and generally make direct investments. They'll do it through a managed fund, through industry fund services, and that's where all the monies are made. And of course, that goes over to unions, which then goes over into the Labor Party. So not all of it, but certainly they do fund it. Incapacity issues are becoming more glaring. Again, we're finding that there's supposed to be a million. There's supposed to be a million or more Australians with dementia by 2030. If they're in an SMSF, you've just got to be really on the mindful for it as well. Okay, so Selma's come up with a really good question. Hopefully someone's got that. How can you do 10-year fees through ASIC? That'd be great, through CAS 360, which is our preferred corporate compliance. The disadvantages, these are all the stuff I've just pulled out, and then we're going to go really. Extra admin. Well, all the platforms are built like that anyway. You can have multi-member. For God's sake, you have a look at Australian Super, their platform is looking after 3 or 4 million members. You'll find that most, certainly I know BGL, you can run separate investment strategies for members. We'll talk about that a little bit, or the next thing. So it's not a big issue. Different members' ages and profiles, well, it's easier. And if you have a look at the ATO investment strategy guidelines, you need to work out the investment, the investment philosophy, retirement objective for each and every member. So if you've got younger members, they're going to be a lot more aggressive. They'll probably put in LRBAs compared to, mum and dad or grandma, grandpa if they're a pension age. So that we can have, for example, different classes of members for investment strategies. So that's accumulation versus pension, or alternatively, much the same as I know in mum and dad's fund, everyone had their own investment strategy, except mum and dad were in pension, all the kids were in that separate fund. We had 3 boys, and that was we ended up having 2 funds, which was crazy. But now with that 5 members, we wouldn't have a drama at all. Chance of fights, that's always the one, everyone's going to do that. But then I think I read the issue from Graham Colley, who has been around for a long time. From that perspective, is he does note that a lot of deeds, and also you must make sure up in the Constitution that voting power is based on, or the votes are based on members' balances, which are fantastic. But if you have a look at our leading member, which is the next stage, the leading member has complete veto power anyway. So everyone has their vote. But again, the leading member, if they've got the EPOA for someone, then again, they still have to have best interest for that particular member. So look, I don't have a big issue with chance of fights. The leading member can hire and fire the trustee and get rid of members if they start to fight. So it needs to be a harmonious family, much the same as if we have a look at a family protection trust or a leading member trust as well. Too many in the fund, 6 is too many, but you have a look at CBUS, it's got 770,000 members, and they offer self-managed super fund options. So they've virtually got wrap accounts. So it shouldn't be that hard in our system. And a 6-member fund, it's just too much, and it's going to sweep up the younger brigade for us. So I see it's an opportunity. Again, coming around from a protection perspective, effectively we're building a moat for you and your client. So this big moat here might be the Family Protection Trust. This other one here may be our Family SMSF. So if we have a look at a really big one, I'm going to look at a protector. So we've got our SMSF there. You can see there's business property in there, SMSF corporate trustee, either leading member or just one of our advanced LightYear strategic SMSFs. Again, if you do the leading member, you can only have bloodline members inside that unless the leading member approves otherwise. We've got our FPA or leading member trust. We've got our trading company there, which has all its exposure, etc. The property is in there. So what happens is the trading company is actually going to shift rent from there to the SMSF. Again, we need to make it market value. Important thing about that, though, is there's a good return to the SMSF. Generally, it's going to be on a higher commercial yield, which is around about between, I think these days, between 6 to 9%. That goes over, plus obviously the trading company pays a lot of outgoings as well. So if we have a look at that, that's really nice, so that it's on the SMSF balance sheet. With the lease, I would, obviously you can do a lease, a commercial lease with us. And I mean, just obviously on the site. From there, you can either do just a month-to-month lease there, or have the FPA holding the lease for the property, and then doing a sublease to the trading company, just in case something goes wrong. Ordinarily with a sublease, if something goes wrong, the SMSF can terminate that lease. But if someone's attacking the trading company, we want to shift that over potentially into that leading member trust, who can then offshoot. So if the FPA, if you've listened to the ideal structure that we've talked about, and we'll be going through quite a bit on our course, is we want to have all the core business assets sitting in there, and effectively, from that perspective, as best as possible, have leasing income going there. Now, obviously, if those core assets can go into an SMSF, that'll be number one place, and this is, again, number two place. Trading company is, we just don't even want to be there at all. Family provisions, we talked about, are deadly, so that, importantly from that, anything which is sitting in an estate, so this is under the various state succession acts, enables an eligible person to make a family provision, or the Supreme Court to make a family provision order. It goes down to grandchildren, provided the grandchildren were living with the parent, or anyone who's living at the household can make a claim. So I've seen one in New South Wales for a friend who was living with the deceased and made a claim on the estate. So you just got to be really careful on that one. So family provisions are deadly. The good thing about that is, with a self-managed superannuation fund, they're only going to be deadly if you transfer the super into the estate. If there's a challenge there, then it's all over. With the SMSF itself, it's protected from a family provisions claim in all jurisdictions. There's only been one instance, which is Kelly versus DeLucci in New South Wales, which I believe was unconstitutional, but they did make an adjustment to the SMSF for what we call the notional estate. So again, we'll be looking at that in detail in the course. But generally, everywhere else, while it's sitting in an SMSF, and the monies are paid out directly out of the SMSF, then it's not caught up in the Succession Act. So that means that if a client wants a testamentary trust, we're actually building the testamentary trust out of the SMSF. So you'll see where you've got your ordinary will, which has got testamentary trust in it. We've got open planning in terms of the SMSF will that enables the trustee to build a testamentary trust, a super SMSF testamentary trust. But what we'll do is we'll be building that in the SMSF will. So you'll be able to tick a box with the terms and conditions, and out will come a SMSF testamentary trust. So that's with the new site, which we're expecting in the next probably no later than 3 months. So that's going to be a fantastic opportunity, again, to shield it from going over to the estate, and again, bloodline member and beneficiaries from there. So the adults are paying monies out. If it's an adult child, monies get paid out, and obviously we have to worry about the 17% tax. Although I'll come around to that and talk about what we've done before. Okay, so these are our new go-to words. We've got our family bloodline superannuation funds. So I'm going to show you a bit of a newsletter I've written for you. It's an older one. I'm going to have to spruce it up a little bit, but we want to get in this concept of building a family bloodline fund. And if you're going down that SAPEPAA space, and we're looking at restructuring, and for those of you who know the Moat Castle, kind of the core components there is upgrading existing SMSFs, or setting up a brand new SMSF if you want, to the leading member ones, that bloodline style. The living SMSF will, I haven't got time to put that in, but I did build one for my mum, which will come up a little bit later on. Looks very much like the SMSF will, but what it does, it's binding on the trustee of the fund and forces the trustee of the fund to ensure that a certain level of accommodation monies are being paid out. Because the danger about it is without that, if you do have the next generation coming in to the fund, or they're doing that, they could, this is one of the fail-safe, they could commute your pension, put it back in accumulation, and then just starve the parent member, holding it over, obviously, for death benefits, which we don't want. So the SMSF living will is much the same as the SMSF will is binding on the trustee. So again, if we're going down this track of adding extra people in, we need to, again, while everyone is poo-pooing and saying, well, it's going to create problems here, it's going to create problems here, we actually use our mind and our thinking capacity and start to use action to work out how we're going to make it safe for our clients. And that's essentially the thing. The good thing about it is you can tell your client for both living SMSF will and SMSF will, if they're other trustees and like they've got the children in as trustees because they've got EPOAs or whatever, or as executor, if they breach either of those agreements, and as a consequence of that, they've profited out of it, you can go to the Commission of Taxation, potentially under Section 202 as a criminal penalty. Certainly you can recover any damages against them under Section 218 and also Section 55.3. So they're both really important because both the living will and the SMSF will, as are your multi-generational pensions, form part of your governing rules, which are virtually sacrosanct, so no one can breach the governing rules. The leading member SMSF, as I said before, really most of the stuff happens, although it's embedded within the deed, most of it happens up in that leading member SMSF corporate trustee. So the leading member is automatically the chairman. They have veto power over all decisions of the trustee. The only exception is where we've got a separate investment strategy. It's essentially left up to the member to do that unless it's deleterious. They also have the power to hire and fire the trustee. So, for example, if there's corporate trustees, they're not getting on well, then they can boot them out of boot that corporate trustee out, set up a brand new corporate trustee and only allow the members that they want to be in there. But mind you, of course, they've got the power to remove a member, and that's a 60-day power. You've got to just give the notice to the member. There's no right of recourse against that, no right of appeal. So they're just booted out, which is really important. As I said before, the superannuation EPOA is really important. We can have our, again, you look at later on life, our children can have our EPOA, so we can have, some point in time, mum and dad just aren't really up to the pace of it. So as a consequence of that, they can sort of bow out, still be a member, or alternatively, they just might be going overseas for a while, and as a consequence, it's worthwhile. Family insurances, we talked about that. That's absolutely crucial because, for example, if we've got a family SMSF, let's say our son or daughter dies, we've got an insurance policy, then we can create income streams for their children, but they're income streams which the grandparents control. And I can tell you, if you control the income, then that child or that grandchild is going to be attached to you for as long as you control that purse strings, which are important, as will the daughter-in-law or son-in-law as well. Separate and member class investment strategies, we've built that into our site. So you've got member-directed investment strategies versus general ones. So again, there's none of this negation. It's just a matter of going through and talking to your client and talking to that next generation. So if a parent talks to their children, and a good thing about it is trustees are effectively excluded from the Corporations Act, so they don't need a license. So they can go and talk to their children about becoming members. And if they then come to you and say, look, I want my child to be a member, you can actually facilitate that whole process. And again, the rollover forms you'll find in that asset guideline, you can facilitate the super streaming or whatever to get that money over, which is really crucial. It's supposed to happen within 3 days under super streaming, but who knows? Contribution to taxpayers and multi-member funds, you've seen me talk about that before, is that if we've got older members who are in that tax-free brigade, we can make a contribution from our family protection trust or our trading company that we saw before. That goes in on their behalf if they're only just living off their superannuation income, so it's tax-free. You can put in up to around about $100,000 each year, and effectively it will be tax-free, so that there won't be any tax to pay. Although you just got to watch out. So there's either personal deductible or it's a deductible because they're working for your family trust. Just be careful though, make sure you do it early in time while you're preparing for it, because you want to make sure that that money that's going in has some good tax plays on it, because that $100,000, if it goes in as a concessional, obviously will be assessable income, or what we call a taxable contribution, which relates to being an assessable contribution inside the fund. So we want to make sure that we've got imputation credits, or if we're investing in ESIC investments, prepaying fees such as your fees, all of those sort of things are important. Prepaying rent, all of that stuff you already know. It's really important to put in. And again, multi-member funds are fine, and don't forget about splitting of income, splitting of contributions. Concessional contribution, you can split 85% up to an older spouse. You just can't split non-concessional, so just be careful. So that's only the cap amount. Family allowance and dependency declarations. So what I've done is I've actually gone through the private binding rulings with the tax office. And so that's a huge grind there, and I'm finding a few gems. But probably over the last 2 or 3 years, there's at least 20 or 30 private binding rulings which have gone down the track of seeking allowance from the Commissioner that clients were financially dependent or independents. I just did one for the executor of an estate who had the late father had a child who'd been looking after quite significantly. We're putting in place a private binding ruling so that the superannuation monies were going directly to her, hopefully will be tax-free compared to all the other children who were looked after from the rest of the estate assets. So again, this family allowance, getting this ongoing conditional amount is really important when you look at these family, these private binding rulings. So attached to that, I mean, if we were doing that and we had a family allowance agreement, we had a dependency declaration where the member was saying these people or these children or these grandchildren are my dependents, plus we can show ongoing support and how that played out directly, then effectively that can make a huge tax saving. To me, that's the absolute number one for us, for all of our clients. It's really crucial. Multi-generational pensions and income streams, absolutely. So that we have, for example, if our grandchildren are our financial dependents, then we can skip it. So the pension can go from dad, and let's say he's over 60, so it's tax-free, to mum. So she receives it over 60, tax-free, and then on to the grandchildren. It can be split proportionally at that stage. Now, because it was originated from dad who was over age 60, those kids, it's going to be part of the pension. It will be tested for their T-bar, but it's not going to be, I can't imagine anyone getting 1.6 million as a grandchild because the 10 will be split. But effectively from that perspective, it will also be tax-free. So to me, that's probably one of the best estate planning gigs that's possible. So in terms of asset protection, estate planning, that's a fantastic one there as well. Obviously with the income, you just got to be careful around what we do with family protection, etc. So that's about it. Has anyone got any questions? I'm just going to show you this, what I'm working on for you around this. And I would suggest that we probably want to, I'll tidy it up, put it on our system. And for Tim, I'll probably, as you can see there, there's a thing I've done there. I'll probably give this to Tim as well to put up in the Change GPS. But talking about the Family SMSF, so we're going through that process there. Okay, so would there be age limit for grandchildren under family allowance? No, Daisy, as long as they're alive at the time of death, that's all. It can be an adult child, could be a 50-year-old child or grandchild, which is going to be unlikely, but there is no age limit. Again, they don't have to be a member of the fund at that stage. They will have to be a member a little bit later on. If it blows out over the 6-member balance, so there might be a number of grandchildren, we can set up a separate grandchildren pension fund if need be. So you can see here, this was written a couple of years ago, but the number of SMSFs have dropped down. So when we go through, I'll tighten this up because this is mainly an advisor letter. I'm going to tighten it up, and I did one years ago for you to send out as a newsletter, which I'll draft up and you can send out to your clients. So there's 3 types of SMSFs. There's the DIY fund, which really it's dangerous, people doing their own stuff, and you don't want to know about that. The SMSF fund, which most of you have got anyway, and then there's the Family SMSF, where we start to bring in, multiple members. Surprising that 20% of SMSFs have only 1 member and 70% only have 2. So I think that this will take us there. And I believe it's not so much a membership issue. I just think that it's, as advisors, we probably haven't talked up all the benefits there, which I do hear, and I'll go through a few strategies in relation to that, why it's important, typical questions and stuff around leading member. So I'll draft that up and we'll get that ready. And that's something that I think is really important for you to release to all your clients anyway by, probably when you get back from 1st of July or after you've done the course. We need to have a really good, strong marketing program or education program for our clients, because it doesn't matter whether the clients take it on or not, but it's better to be in their face about it. So with all this family protection, leading member trusts, etc., do these entities help with banks and personal guarantees if all goes wrong? Absolutely. So with the banks are always going to have, so Paul, banks are always going to have your personal guarantees, and also they're going to have your registered mortgage. In terms of personal guarantees, with the Family Protection Trust, that'll be a secured loan, a second mortgage. So the personal guarantee stands at a lesser rate than that. Obviously, that if you've got a second mortgage, you have to pay off that loan first before you go to personal guarantees. So definitely that case. In terms of banks, though, it's crucial. So when you are doing a protect and you're shifting assets over, Paul, it's a really good question that you raised, because you want to be in a position that if you've got your cars, you've got jewelry, you've got the key items, it's important to shift those over. Remember, we've also got the call option in there, and then get Michael Jeffriess to put a PPSR over it. So again, it lifts it above those personal guarantees, which are really important on that one. So really good question. Thanks for that, Paul. Anyway, look, you probably heard enough from me this year. We're building out all of our sessions between now and 1st of July for the next 6 months. There's going to be a lot going on. Do you want to give a bit of an update on your ESOPs and all that, Mick, and also what your view is around the 6-member funds?
Oh, mate, I think the 6-member funds is
fantastic. You might need to
fantastic.
talk up a bit. You're very quiet.
Yeah, is a bit quiet, is it? Can you hear me?
I can hear you, just still very quiet. Can everyone else hear, or is it just
me? Can you hear me now? Is that better? Is that better?
And maybe it's just me.
No.
Yeah, I think it's just me. That's it. Perfect. It's just my speakers. Sorry about that.
Okay. So you can hear me clear now?
Yep.
Yeah, I think the 6-member fund is fantastic, and I agree with what your comments at the start in relation to Liberal government. I probably think maybe they'll do it pre-Spring Carnival, because Spring Carnival is potentially a breeding ground for COVID.
Yeah.
And why not get out before the horses start running around in pre-Melbourne Cup and get another term under their belt. But in terms of what we've got going on, my partner solution series next week is going to be a fun one. It's normally on a Thursday. We're actually making it on the Wednesday, which is the 30th of June, which is New Year's Eve for accountants and advisors. We're doing 11:30. I'm taking my team out from 12:30 onwards. I've got Tim Munro, Peter Morris Stewart, and Shannon Schmidt joining me at the moment. We might add to that, but we're going to talk about the financial year coming, what sort of planning we've done, what's coming out in relation to LightYear Docs 2.0, change GPS, and a few other cool, fun things like that. We might even get Grant along to that as well. So we can have a couple of drinks at lunchtime.
Yeah, I think there's next year is going to be a fantastic year. A good thing with a lot of the stuff that we're doing is, I know even if the market shits itself or whatever, this stuff is it's beyond the money side of things. What I've noticed, and this also goes down to that super side, is that probably over the last 25 years, there's been a huge increase in super, obviously in people's balances, courtesy of SGC. The market's going up, but the other side is also that the underlying equity for those people lucky to have homes or investment homes have gone up quite considerably. But unfortunately, most of that is sitting in their own name. So like the worst case scenario you'd ever have would be to have all the assets in your own name and then a retail superannuation fund. That's like the worst in sort of asset protection. So there's huge opportunities down there, and I'm looking forward to hearing what all of our advisors are doing and what they're going to focus in on next year as well.
Definitely.
And how's your ESOPs going?
Yeah, good, Grant, especially after, which I just grabbed. We, last Friday, went down and Sydney, and although I'm starting to believe that I might be forced into quarantine any moment, I saw the New South Wales health order saying that I have to wear a mask now for the next 14 days. I've been tested and apparently might have to have another test in 11 days. But the ESOPs are going well. We're getting a lot of, obviously on the back of winning the Australian Accounting Awards, we're getting a lot of our parent or our sister company, I Love Accounting, is getting a lot of expressions of interest. We're rolling them out, quite a few now with LightYear members and their clients. And you've been helping me in relation to reviewing and rejigging our documentation a bit, and on that side. And it's when, especially with the cake, we did the cake webinar fortnight or a week ago, and that's just fantastic. And we've been using that obviously for the capital raise side of things, which you and I've both found to be so efficient and streamlined, and also in the shareholder communications has been great. So
yeah, it's great. And for those of you who haven't, I think we've hit our minimum for our capital raise, which is fantastic. So that's all going into LightYear Docs 2. We've got a team of 21 working on it at the moment. So that's going to just blow you guys away compared to what we've got now.
Pretty close to our maximum. So if anyone was thinking about investing or had any interest, I think I've only got about 100K left. So
yeah, and if you see what we see on the other side, so I can't really talk about it to any great extent because I don't want to pump things up, but there's some amazing stuff coming down the track, additions to our sales team, our distribution teams. Look, I think we just had our first order through from My Prosperity the other day. So we're really picking up a lot of stuff. Mick won an award. We got award for the Startup of the Year #6 and the Total Wealth and SMSF. So, we're really on that an upscale, and that's with a pretty I think we all would say that's through a clunky old system that we've got now. The back end looks well, but that hot docs. But yeah, look, I think there's going to be huge opportunities, and we're certainly going to be gunning for those 100,000 ClearDocs users and the 10,000 class users as well. So the world is our oyster, and everything's up, and we've got the best quality and also the lowest price in the market. So again, if you want to invest, just have a chat with Michael. So it's a very low pricing at the moment. But look, next session is there you go. Thanks, Daisy. I was a ClearDocs user, now LightYear. Yeah, thank you very much for that. That's because those guys don't give you proper support. I know. I spend most of the time, my day, apart from doing documents, is on the phones to you guys. So you can't get a better level of support than that. But look, thank you very much for attending. Next week, 30 June, with Mick, and we'll be doing a lunchtime session. And then no doubt he'll probably be having a beer at that lunchtime session, getting ready. Definitely. To go straight into his big, long 30 June lunch. Anyway, thanks for turning up today. Thank you, everyone else. I know it's a busy time of the year, but again, this is a day I've been waiting for God, since 1994. So it's a very exciting day. most people won't even understand it until it's run over the top of them. So, let's open our minds, open our thinking, and build strategies and solutions, not just simply close things down because our minds aren't open enough. Anyway, it's Grant Abbott, Mick signing off from LightYear Docs and Abbott-Family.